wait. It was really unusual that they just popped this thing open and gave it.
Okay, real good, Dave. We've got a visitor here with us today, Josh.
Josh.
Okay, Dave, how do you respond to that statement by Freeman that I feel the situation deserves the spending of some $500,000 in fees to prove the case, because if I am right, then the rewards will be very beneficial to both you and me and the Zeringer family?
Well, obviously Mr. Wolt was conning somebody out of something along the way, because he didn't want to spend the money and knew that Horace wouldn't spend the money, and if he knew that Horace wouldn't spend the money, then he knew that he had Horace in his pocket and would rather save his money than pay it to Dave like he was supposed to under the contract. So it's just a slip of spending money to make something equal. It was bullshit. It was already okay. It should have just been administrated.
Well, we mentioned this topic before, Dave. Where did you feel that Freeman came up, or rather, where did Wolt speculate that he could pick up that $500,000, $500,000 from?
Well, from the bank, for the bank stopping the harvest and the bank putting me in a position that was actually contra to the contract. Although Wolt and the Zeringers would have made money if the bank would have been sued back then, and he had a lawsuit against the bank, Mr. Wolt, but he didn't pursue it, because once Horace agreed to not pursue him for the money, he was more than happy to let it go and not pay his bill and cooperate with Mr. Wolt. In the beginning, back in Ortonville, before all this happened, I had two attorneys that I'd worked with, Ron Frauenschuh and Dave McLaughlin. Dave McLaughlin and I had pursued several different cases and won all of them, and most of them out of court, because we had the right information and the right technique and strategy, and we settled them. Now, these two individuals are very knowledgeable of my operation, but in the process of bringing Mr. Wolt in and talking with Mr. Watson, these two people got literally cut out of the situation, because Mr. Wolt had fabricated the whole event. And Mr. Watson, the prosecutor, bought it hook, line, and sinker, never doing his job to investigate, was there any money actually missing, or was it just a billing to correct an error that had been and come before that with ASCS.
How did you feel the relativity of the Wolt letter that mentioned the LDP swindle, wherein Wolt mentioned that if Horace was holding payment on fulfillment on the contract, and at the same time was receiving all the LDP payments while you held all the leases. What's your opinion of that particular?
Well, it was set up so that 7 partners would each receive their benefit of the LDP. Now, the LDP was also part of a loan that they needed in order to capitalize themselves in the company and make the ASCS documents correct as to ownership and so forth and so on. But Horace's and SVO's position was that these flowers couldn't be grown unless we had the LDP captured, which was a considerable sum, somewhere around $500,000. But it was Horace's demand that these issues be met, and then his failing to meet the capitalization as required under ASCS rule and regulation that blew the whole thing up and cost me over $1.4 million in ASCS funds. Well, in late January and early February, my wife and Mr. Wolt were colluding on a miscue, and Mr. Wolt commented to me, well, if you don't do something, your wife and Phyllis could go to jail out of this situation. And of course, not wanting them to go to jail or anybody to go to jail, and not actually even understanding what the hell he was talking about, I went in to make sure that the information was correctly given and the arrangements between myself and Ceres and Satius was correctly understood. However, I didn't realize at the time that the prosecutor didn't have the acumen to understand what was going on so that it could be administrated. And many times the prosecutor repeated to me, well, I don't know much about business. Well, it turns out he knew very little, if anything, about business. After Mr. Wolf had confused Mr. Watson, and Mr. Watson had then filed charges against me, I was appointed a court attorney because I had no funds left. Mr. Wolf had made sure that I didn't have any access funds to hire an attorney. Instead, they gave me a public defender, Mr. Tollefson, who, when I requested that the information about this alleged loss and the whole contract be exposed, he said, oh, you don't want to do that. It'll just cause more charges to be filed against you. I won't do that for you. We don't need that. Deal with this. Which, in essence, he took away our whole defense by not addressing exactly what it was they presumed I had taken from Mr. Satius. After Mr. Tollefson had been appointed, he didn't have time for the case for some reason, and they passed me off to a fellow by the name of John Holbrook out of Wilmer, who was then in charge of the case. And he also made the same mistake Tollefson did, in that he wouldn't review the facts around the alleged theft, around the contract. The contract was central to everything, and he completely avoided that, to the point that he thought that it was a good deal that I should take a plea bargain, when if he'd done the accounting, he would have found out that there was no money missing and I was owed money by Satius. Not that I owed Satius money. This carried on then into the federal case, and with an attorney by the name of Jeff Thomas, who I thought at the time would be able to handle this and understand this. But as Mr. Thomas rolled through the information, he too would not review the documents in the accounting and said, I can't do anything in a civil case and we can't go back to that civil case. Me not knowing that that was where all the errors lie, I couldn't fight with or argue, and even when I questioned him about getting a different attorney, he simply made the same case over, that any public defender doesn't have the ability to review civil cases, which was the whole basis of this. There was a collateral estoppel that should have prevented any charges being filed that nobody got, because nobody actually investigated the civil case, the collections thereof of the bank, which were inaccurate and in error.